Good afternoon. Harriet, can you hear me?
Yes, I can.
And are you all set?
Yes, I am.
Wonderful. All right. Well, then, good afternoon. Let's go on the record in proceeding number 25A-0086R, which relates to the City of Arvada's application for authority to construct a permanent grade-separated crossing, as well as a request for a cost allocation for the crossing. I am Kelly Rosenberg, the administrative law judge assigned to this proceeding. We are here pursuant to decision number R25-048-I, wherein I set this pre-hearing conference to discuss specific issues and directed the parties to confer on certain items. This conference is scheduled for 2 hours. I do not anticipate we will need 2 hours. If we take all that time, that's of course fine, but I like to set things to have more time rather than not enough time. And at this time, I would like to take appearances, starting with the City of Arvada.
Thank you, Your Honor. Brandon Dittman of Wilson Williams Fellman Dittman appearing on behalf of the City of Arvada. Kelsey Sargent of the City Attorney's Office is also appearing today on behalf of the City of Arvada.
Thank you. And Union Pacific?
April Connolly, Your Honor, on behalf of Union Pacific Railroad.
Great, thank you. And I have just a couple of very preliminary items to discuss. First, I'd like to inform or remind all participants that it is the Commission's practice to record and webcast legal proceedings, including this one. And we have a court reporter recording every word stated. Second, if I mispronounce a name or if I use an incorrect gender pronoun, I mean no disrespect, please just correct me and I will do my best to get it right from there on out. And now I'd like to discuss items that were addressed in the decision. And first is to discuss Arvada's request for preliminary approval of its conceptual level design plans / drawings. And as I noted in the decision, this is directed to Union Pacific, Ms. Connolly. I wasn't sure if Union Pacific's objection was to Arvada's request for preliminary approval, final approval, or both.
I would say for both, Your Honor, but I also would just like to say it's my understanding that the parties have conferred, and there is currently a settlement agreement in the works, in which we are trying to resolve a lot of these main issues. That is in terms of the pretty much everything that Union Pacific addressed in its objections. And so my understanding is we're very close to entering into a settlement agreement. A few versions have been passed back and forth, comments between the parties.
Okay, great. And I understand that, and that sounds wonderful. Let's just still sort of knock out a few items here since we're all here. But I understand that, and I appreciate that, and that sounds very good. With regard to Union Pacific's objection to the preliminary approval, did you want to explain the basis for the objection to that preliminary approval? And if you did that, did you want to do that here? Did you want to write a motion? Or just state an objection for the record and then we move on? Your call.
Your Honor, I have a few people here on Union Pacific's behalf, a few from the projects team, from the legal department that might be able to address more specifically that concern if we wanted to do something on the record. I also don't mind just doing a brief motion if that's easier for the parties and saves time.
Why? And when you say a brief motion, did you mean a written motion?
Yes, Your Honor.
Why don't we sort of proceed with that in mind, understanding, and we can get to like deadlines for that and things of that nature in just a bit, because potentially it sounds like there may not even be the need for such a motion. But
Yes.
Mr. Dittman, did you have any input on that
No,
approach?
I think I understand from the intervention, the opposition of Union Pacific. If they would like to file a motion to clarify further their objections, I would not object to that process. I guess the only thing I would add is that they could also clarify via answer testimony potentially, what the specific nature of their objections are.
Okay, thank you. Okay, so that's good. And for now, we'll sort of address the timing of that in just a moment here. But second and relatedly, Arvada says it's working with Union Pacific. And so it does sound like the parties have made progress with coordinating things. However, when does Arvada want Union Pacific? And I'll get Ms. Connolly your take on this as well. But when would Arvada want to have the Union Pacific to finalize all outstanding plan sets? What would the timing of this look like? So then you could amend the application.
I mean, as soon as possible, but realistically, I think we are very much in a place where will happen. I think, by the middle of July, it sounds like, through the party settlement negotiations, I think we will have all plan sets finalized by that point, it sounds like. But I mean, the city's position all along, and, the reason for filing this application is, accelerating this process towards construction.
Sure, understood. And then Ms. Connolly, what do you believe Union Pacific could get information by mid-July relative to finalizing the plan sets?
I believe that's fair, Your Honor. Yes, mid-July.
Okay.
Yeah, and potentially sooner, I would say. I'm just trying to be safe, but, given the parties' discussions, I think, we can get it done by middle of July.
Yeah.
And then similarly, Mr. Dittman, when could Arvada then amend the application to have once all the final information is obtained?
I think we can amend the application within a week of receiving
Okay.
the final plan sets.
Okay. All right. So then let's say we're then getting to mid to late July. And I did note in the decision that we would set the hearing today, and we still can, but if it's I understand sometimes in these scenarios, it's too difficult to go back and forth looking at calendars. So I thought about that after I issued the decision. So did you all discuss potential hearing dates with these deadlines in mind? And if you didn't, that's okay, because it sounds like you're doing a lot of talking anyway. We can finalize things via email, because sometimes I find that to be more efficient. But do the parties have any general thoughts on timing of hearing?
My only kind of question / thought is whether, we would be scheduling answer testimony and rebuttal testimony to be submitted. And so that way the hearing would be on cross as is practice when we pre-file testimony. Is that will, I think, impact, when we would set a hearing, allowing for those processes to work out. But I think,
Yes.
given the parties' progress, so far, not wanting to, excuse my pun, derail that progress, it would seem that we would, want to set an answer deadline, August, kind of early at the earliest, rebuttal 3 weeks after, and then a hearing, maybe a month after that would be fairly typical, I would think.
And that general timeline works for me. Does that work for Union Pacific?
That works for me, Your Honor.
Okay. And then were the parties thinking one day with a second day, 2 days, or what is how many days do you anticipate?
I mean, I think honestly, and what's actually in dispute, which is mostly just the cost allocation, we could probably do it in a day. I mean, usually my practice is in these to reserve for a day and then, keep an extra one in the pocket in case we need it. But I mean, I don't see this going over a day if we're just doing cross on the record.
Okay. And that sounds good to me, Ms. Connolly.
I generally agree. I think I'll leave it to the court. I think 1 day would be fine if we want to schedule it for 2, just to be safe, and then we can have a day back if, if we don't need that extra day. That works for me.
Okay, great. How about this? If this is okay with the parties, I will take this information. I will send an email to everyone with some proposed dates based on the discussion we had. And then once we get that hammered out, then I can issue a written decision, finalizing it, understanding you're all working on a settlement.
Yeah, and that settlement, just to be clear, still needs to be, reviewed by city council, which it has not at this point. We're not. There's a process for municipal agencies to do this. Is all I want to say. So, but we are working on a staff level right now.
Okay, and then if things change in the parties under these circumstances, if you feel that you need to continue or, sort of stay deadlines for the hearing, so you're not pursuing 2 tracks, settlement in earnest, and then hearing prep, let me know, and then we can go from there. I just don't want to not take advantage of us all being here and getting things moving forward, since you don't have a settlement yet.
Yeah, I think we could file a joint motion requesting a stay of dates if necessary.
Agreed.
Okay, great. And then just to confirm, so based on what I heard and just based on the notes I just took, it looks like we're looking for potentially hearing dates mid to late September. Is that what everybody here understands?
Yeah, I would think so.
Yes.
Kelsey, do you have any input on that? Does that sound right to you?
It does.
Okay. Great. Well, then what I will do is take all of what we've discussed. I'll send the email. I will issue a written decision, but I won't issue that until we get our timing finalized regarding hearing date, things of that nature. And those were the only items I wanted to discuss. Mr. Dittman, do you have any other items to discuss?
I don't think so. I just want to let Your Honor know that I do have other hearings scheduled for September, and so I am unavailable the 3rd and 4th of September due to another hearing that I've scheduled, and then it looks like the 11th potentially that one may get moved, 11th and 12th currently. So
Okay,
just want to make you aware of those dates.
appreciate that. Okay, and Ms. Connolly, anything else? And if you have any dates that out of the gate aren't going to work in September, if you can let me know, it's okay if you don't.
The only date that wouldn't work for me in September looks like it would be September 22nd. Otherwise, I'm generally available.
Okay.
And I didn't have anything else, Your Honor.
Okay, great. Well, I appreciate everyone's time. And yeah, this was much shorter than 2 hours. So great, thank you. So you can expect an email from me and a written decision after that, after we get everything finalized. And thank you everyone for your patience. I apologize for sometimes it takes a while to get decisions out. We just have a process and prioritized decisions go out first. So thank you for your patience.
Thank you.
All right, have a good afternoon, everyone.
You as well.
Thank you.
Thank you.
Bye-bye.
Thank you. Bye.
Bye.